Welcome back to the channel, folks. Today's case is one of the most jaw-dropping courtroom showdowns we've covered yet. Picture this: a defendant with a history stretching across nearly 10 prior cases, weapons, charges, assaults, even a felony against a pregnant woman standing in front of a judge, yet again. But this isn't just any routine probation hearing. Oh no, what unfolds here is a legal chess match over whether his latest arrest truly qualifies as interference with public duties. The defense insists it doesn't, while the state argues otherwise. And when the judge digs into the law itself, things get fiery. We're talking contradictions, accusations, and a moment that leaves everyone in the courtroom stunned. Stick with us, because by the end, you'll be questioning how vague laws can sometimes turn the entire justice process to a gray area. Let's dive right in.
Evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon.
Did you catch that? This defendant is standing here on his 10th case in barely 2 years. That's not a streak, that's a pattern. Now, the defense is quick to say, yes, but those were all dismissed. But here's the catch: dismissed doesn't always mean innocent. Sometimes cases collapse because of lack of evidence, witness issues, or plea deals. So the question is, does this string of dismissals make him unlucky, or does it make him a repeat offender who just keeps slipping through the cracks? What do you think? Mistake-prone system, or a defendant who keeps skating on thin ice?
Another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may.
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the aetv located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection.
Let's pause here. The officer's report is painting a chaotic scene: multiple 911 calls, threats to slap his partner, marijuana found, and outright refusal to cooperate. Now, in law, the difference between resisting arrest and interference with duties can be razor thin. One implies obstructing an officer's lawful authority, while the other leans more toward non-compliance during an act of duty. This distinction matters because the charge you face can decide whether you're looking at probation violations or straight-up prison time. Already, you can see why this case is about to ignite a legal firestorm.
0.1 miles away from the HEB where the original call was
Observe
located.
what?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW And another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure, please.
Where's the interference? Okay.
Well, they're putting him in a car and he's
how-
like going
Judge, how-
plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand
and they're a 0.1 mile away from the location
So-
for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a
This is key. The judge just reminded everyone probable cause is not guilt. Probable cause simply asks, is there enough evidence to justify going forward with charges? Think of it as the courtroom's green light. But here's the drama. Once that light turns green, the defendant is dragged into months of legal battles, hearings, and possibly jail time even if they're ultimately found not guilty. So in reality, probable cause can feel like punishment before the trial even begins. That's why defense attorneys fight so hard at this stage.
potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the
Here's where the legal fog sets in. The statute on interference with public duties is so broad it practically leaves room for interpretation. The wording interrupts, disrupts, impedes, or otherwise interferes is vague enough that almost a nigh resistance, hesitation, or even verbal pushback could be labeled a crime, and that's dangerous, because vague laws give law enforcement and prosecutors enormous discretion. The defense seizes on this immediately, arguing it's unconstitutional. The judge admits it's vague, but vague doesn't always mean invalid. This is where courtroom law meets courtroom reality.
code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, you're right, it could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described.
They put him,
the
I guess, did they put him under arrest at the time when he said that he was making that threat?
And with being.
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's
I
a
mean,
resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but
we don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
I
Judge.
don't care. I mean, but I think that there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
Listen closely. The judge is hammering home that the standard here is incredibly low, probable cause, not beyond a reasonable doubt, not even a preponderance of evidence, just enough to say, maybe he did it. That's a heavy reminder. The system doesn't need airtight proof to keep a case alive. And for someone already on felony probation, that low bar could be the tipping point between freedom and a lengthy prison sentence. Do you think that's fair? Should a low burden like this carry such high stakes?
I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with.
Remember,
Right, I haven't had a
Guys,
chance.
this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video? Here on. He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then we
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year.
This is one of those human moments that cuts through the legal jargon. The judge flat out tells the defendant, when you're on probation, you're supposed to be on your absolute best behavior. Any slip, no matter how small, can cost you your freedom. And yet here he is, fighting in public, making threats, getting arrested again. The judge compares it to cancer, something you have to cut out before it destroys you. That's not just legal advice, that's life advice. But will the defendant actually take it? That's the bigger question.
You're on probation, dude. On felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know? And I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it. They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge,
Wow.
but the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes,
So it was allegedly committed prior to, now nevertheless, it's still a
it
warrant,
was,
but how on earth has it never been?
it's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that there's a, Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his.
Reading in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that. And another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge,
And this has been going on for years out there, like prior administration continuing.
But I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's going to look and see that was like extremely old, right?
And here's where the finger pointing widens. The judge openly calls out Fort Bend County for failing to execute warrants on serious felony charges. In plain English, that means this defendant has been walking free despite active warrants that should have put him behind bars months ago. This isn't just a story about one man's bad decisions. It's about systemic breakdowns where dangerous cases slip through the cracks. And when that happens, justice delayed often means justice denied. How many other cases like this are quietly piling up?
I would have the first time he failed.
I'm not gonna read it. It doesn't matter.
Okay. Is in,
I mean, it doesn't matter. It's on video. It doesn't matter.
Okay. Parents required, but no,
correct.
if he
Right.
pays.
On video, guys. Like, I watched it. I'm not crazy. Like, this, it's on video.
Sorry to keep
Let's
debating.
talk to Judge about it.
Okay. You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always. Why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable.
Now comes the defense's strongest card, the video evidence. According to them, the defendant wasn't resisting at all. Instead, the officers were being overly aggressive, pulling him out, pushing him back in, searching him multiple times, without clear justification. Video evidence is often the make-or-break factor in modern courtrooms, but even video can be interpreted differently depending on who's watching. One side sees resistance, the other sees compliance. Here's a question for you. When you watch a police arrest video, do you trust your eyes or the official report?
To do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's
he-
why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's all-
common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge,
And I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
we can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow? So we can all watch?
We can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology. The whole video, or did you?
No,
want to-
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you wouldn't just put it right there and just turn it around.
Yeah, just put it
Just
up
right
there.
there on the table. Yeah, right there. You said it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him.
Now you're under arrest.
I'm under arrest.
Yep,
for
you got a
what?
new charge, Bubba. Resisting transport.
Resisting? I wasn't resisting.
You just resisted transport. Yep. You go to
What
jail.
the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
These
Judge.
officers are working intake, Judge.
Did you catch that reaction from the judge? The defense is practically begging the court to see this as resisting, not interference, and honestly, they've got a point. Even the officers themselves seemed confused, calling it resisting. Transport one moment, interference the next. That kind of inconsistency is exactly what defense attorneys love to highlight. But here's the kicker. Regardless of what label you slap on it, the bottom line is the same. The defendant was fighting against being placed in custody. Whether it's resisting or interfering, both can land you in prison.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm
Do
with
you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
You can refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
And just like that, the judge shuts it down. No probable cause for interference. That's a win for the defense today, but don't celebrate too quickly. The defendant still faces other serious charges, plus probation violations that could send him straight to prison. This case is a stark reminder of how messy courtroom battles can get, especially when vague laws, repeat offenders, and system failures collide. But what do you think? Was justice served here, or did the defendant just catch another lucky break? Drop your thoughts in the comments below. And if you found this breakdown as intense as we did, make sure to hit that like button, share this video with a friend, and subscribe for more jaw-dropping courtroom showdowns. Until next time, stay tuned, because the verdict is never as simple as it seems.